story, and it's about what many people say is an attempt to put the Gandhis in a box. And we're talking about the Herald House case. A Delhi court on Tuesday refused to take cognizance of the Enforcement Directorate's money laundering case against Sonia Gandhi, Rahul Gandhi and 5 others. This is also known as the National Herald case. The Rouse Avenue court said the agency's prosecution complaint filed under the Prevention of Money Laundering Act or PMLA was not maintainable since the case was based on a private complaint filed by BJP leader Dr. Subramanian Swamy and not a first information report or FIR. The court also pointed out that Delhi Police's Economic Offences Wing had already registered an FIR in this case, meaning it will be premature and prudent to now rule on the ED's submission. So let's open this up and ask, because the Congress party has come out and said very clearly that we are right, this was a witch hunt, we have scored a famous victory, and that at the end of the day, this is a massive reprieve from a witch hunt. So I just want you to come in very quickly, Shahzad Poonawalla, and explain why you differ with this point of view when the court has clearly, and a lot of things have even been said about the ED by the court, by the way.
Right. Now let us focus from today's order. Today's order has made no comments on the merits of the case. It denied the Gandhi family an acquisition of the FIR in this case, and all that it said that the current charge sheet wouldn't be taken cognizance of, which was known to everyone simply because it was at the back of a private complaint, and the law after 2022, in particular after various judgments of the Supreme Court, is very clear that the ED needs to have its what is called as the case that needs to be done, it has to be in an FIR. So pursuant to this, following the law, which is actually good for the accused because the accused then has a right because he has a proper FIR to access. The EOW case was already filed in October, and in that the entire case has been described as to how the 2,000 crore property was usurped by one family using a special purpose vehicle. By the way, if they want to quote, if they've got relief, in the criminal case, they went right up to the Supreme Court, no relief, they're out on bail. In the IT case, they challenged the IT Court Tribunal's orders, no relief from the Supreme Court, and even in the ED case, 900 crore worth property has been attached and they've got no relief. So this is, you know what, it is to manufacture a relief, then feel happy about it. The fact of the matter is that today the ED has a bulletproof case after the FIR has already been lodged in pursuance of its statutory and constitutional duty after the October 3rd, 2025 FIR. Okay. And therefore, they can celebrate as much as they like, but that is only in their minds.
Very quickly, you were raising your hand, Doctor.
Yeah, no, very simply, I'd heard of multiplicity of agencies. What is this multiplicity of charge sheets? What Shahzad said is quite right. You have an FIR that has already been registered and the case is being pursued there. So a very simple question. Why did the ED maintain this charge sheet that was based on a private complaint? Why did it not tell the court that we are taking back this charge sheet? It's a very simple question.
Can I answer that question?
Yeah, so I'll just say, law officials raised doubts only after magistrate took cognizance in the complaint case. ECR maintainability was questioned much later. This is the point.
Let me answer. Because when the initial case was started by a private complaint in 2012, at that time the then judge who made scathing observations against the Gandhi family and started the criminal prosecution also said that ED and IT should investigate in it. So they had the basis of the ED investigation was the 2012 order of the court. Now, based on a private complaint, the investigations continued with the ED. But 2022 onwards, there are several judgments where the Supreme Court has now necessitated. Earlier, a private complaint could become the basis of a ED investigation. But now you need to have an FIR cast in stone. That is the law after 22-23. So after that is the case, in pursuance of the legal situation right now, that has been done on October 3rd. So that has been done. So therefore, this charge sheet, it takes a back seat, and the FIR that has been filed is the actual basis.
Can I ask you a question, Nikhil Jain? Look, we don't want to get lost in the woodwork here, in the woods, in the weeds, so to speak, because the court has not given a clean chit. It has refused to register this particular charge sheet because it says there is no FIR and so on and so forth, but there are other investigations going on. So let's just set that aside and let's say that you've got a reprieve and you're very happy with this reprieve. And in fact, the Congress has come out and said, Satyamev Jayate, the truth always wins. But is your acceptance of verdicts selective? Recently, just about what is it, 2 weeks ago or something like that, the beginning of December, a judge came out and gave Hindus, for example, the right to worship and light their Deepatun. And you have signed on, and I'll show you those visuals, viewers. They moved a petition, a notice for impeachment against that judge. So I want to ask you, Nikhil Jain, when does the judiciary become okay and when does it become bad? And how does this definition continually change or the goalposts change?
Rahul, since you're asking me about two different questions, I hope you give me the time to respond to both of them. First of all, the impeachment motion or the removal motion that was filed for the particular judge was filed by the DMK. It was, of course, supported by the Congress, and it wasn't on account of the judgment that was given in the Deepatun case. It was on account of misconduct that the judge had been exhibiting for a long time. There had been letters written by former judges of the High Court. There were calls by the bar.
It only after the
He's given an order on the 9th of December. He's given an order which flies in the face of a binding order of the Madras High Court in 2014, which had already settled the case.
Wrong.
And
today the court has come out and said a double bench. No, 1 second. I just want to make a division bench has come out today, viewers. Maybe Nikhil Jain hasn't opened that page on his Google. Please Google it. The judge today has come out and said that a single judge bench, the division bench has come out and said that the single judge bench was within its right to proclaim an order. It's written there, viewers, today. It has just come out. It's breaking news. Yes, Doctor.
Rahul, there is a 2004. Can I please?
Wait, today all
Now
these
you
things
can't
are argued
interject
in
me
the
the middle
court,
of
sir.
my point.
Today,
In the
don't
middle of my point,
always
you
argue
interject me.
about everything,
In the middle
sir.
of my point, you interject me. You never asked Shehzad or Anand for any proof. For every single word that I say, you want proofs with Oscula.
What proof do I ask him? In the last debate, do I ask him for proof to show how many Rafales fell out of the sky?
Can I at least make the point? The point that I'm trying to make is that we are talking about the National Herald case, in which case no property was ever transferred to the Gandhis, no property was ever leased by the Gandhis, no property was ever used by the Gandhis, no money ever flowed to the Gandhis. The ownership of the properties continues with Associate Journals Limited.
The question I asked is, gentlemen, viewers.
Associate Journals Limited is taken over by a non-profit company, yet the ED
led
is
by
going
the
after the Gandhis by this witch hunt.
Even his lies have frozen.
Okay. No, very quickly. 1 second. Very quickly. Yes. One second. Very quickly. Yes. Doctor. Doctor, 1 second. Doctor is raising his hand.
The person who's the trustee is the primary beneficiary of it.
Okay, sir. Okay. Wonderful.
No, whatever Justice Jain is saying, I of course take it with a pinch of salt. I respect
Dr.
what Justice
Ranganathan,
Jain.
what are these juvenile jibes? Are we in high school?
Please.
Are we in high
Nikhil, I didn't
school?
interrupt.
Dr. Ranganathan, what are these juvenile jibes? No, you were
But he's
interrupting
called
with
you a
these
judge. Why
Justice
are you
Jain
feeling
jibes and
so
all of
excited?
that.
Call him a Qazi. Call him a Qazi.
No, please. Come on. Let's not get into all of this. Yes. Yes,
Can I call
sir.
you a protein ka
Nikhil,
dabba?
please.
Yes,
Are
sir.
we here to
You
do
can,
juvenile
I'm strong.
banter?
1 second, please. Yes, doctor. Yeah, go ahead.
Be happy with that.
It's a very simple. And please, Nikhil, you are now basically narrating why, in your opinion, Rahul Gandhi is innocent and should be acquitted in the National Herald case. That's your opinion, fine. But can you? It's a simple yes and no question. Is there a charge sheet on National Herald State which is currently maintainable? Yes or no?
Yes.
Answer, Nikhil.
How does the presence of a charge sheet make somebody guilty? How does the presence of a charge sheet make somebody guilty?
Charges
That
have
is
been taken
ridiculous.
cognizance
What
of. They are out on bail.
What ridiculous line of argument is
Okay,
that, Dr. Ranganathan?
viewers, the point is this.
Beating your head like that isn't going to make the argument better.
Everyone's face is down. Viewers, this matter might appear like a technical relief for the Gandhis, but it's actually not. They have not had a reckoning as yet. There is no clean chit, and the judgment actually says it. I leave it at this, viewers, because in any case, this case has been dragging on for years, and the BJP needs to respond to one question. Why is it that it has been dragging on for years? It's been almost 12 years, viewers. I leave it at this.